What happens if you die without a last will and testament? If a person dies without a last will and testament, they are known to have died intestate. Think of it like this. A person failed to testify as to what they wanted to do with their assets after death. Hello again. This is real estate broker Daryl Williams here in Southern California. I'm a certified probate real estate specialist. On this program, we assist attorneys, executors, administrators, and successor trustees with real property that's going through the probate process. If you're interested in that type of content, please subscribe. Let's get started in today's topic. Wills must be created when you are of sound mind and not under duress, and you need two witnesses that are not beneficiaries of the will. If all of the prerequisites of a valid will checks out, then your will be validated in the probate court. If all of the prerequisites do not check out, it's possible your will be invalidated, and the laws of intestate succession will govern the estate. Remember, when you are trying to determine if you need a will or not, there are certain assets that are not affected by intestacy laws. Assets in a living trust, real estate owned as joint tenants, or community property with the right of survivorship, life insurance benefits with beneficiaries, IRAs or 401ks, retirement funds with beneficiaries, stocks and bank accounts owned in a payable upon death account. And this list is not intended to be all-inclusive. If there is no living trust and no last will and testament, who gets what? Procedures have been established by each individual state to dictate that fact. For example, here in the state of California, if you pass away and you have a spouse or domestic partner and no children, your spouse or your domestic partner will be entitled to your assets. If you pass and you have a spouse and one child, your spouse receives half, the child receives the other half. If you pass and you have more than one child, the spouse receives 1/3 and the children receives the rest. Last I checked, stepchildren do not inherit anything via intestacy laws. Sorry, stepchildren. If you die without a spouse and no children, state laws will generally leave your assets to your relatives in the following order of priority: grandchildren, your parents, your siblings. If your siblings have passed, your nieces and nephews, your grandparents. If your grandparents have passed, your aunts and uncles, or relatives of your deceased spouse. There it is. If you die intestate, that means you died without a will. And the state law of intestacy will govern your estate. If you do not want that to happen, make sure you complete a last will and testament, or better yet, a living trust. I'm Daryl Williams. This is Win-Win Realtors TV. If this program has been of value to you, be sure to smash that like button. Thanks again, and I will see you next time. This is not intended to be legal advice in any shape, form, or fashion. I am not an attorney. If you need an estate planning attorney, feel free to contact me for referrals.